Module 9, Performance Outcome Area 7. Welcome to Module 9. My name is Doris Akol. I'm the former Commissioner General of Uganda Revenue Authority. This module is POS 7, and it is about effective tax dispute resolution. This POA deals with the process by which taxpayers seek an independent review of an outcome of a tax audit or investigation that has identified a discrepancy that is disputed by the taxpayer. The request for a review could be on the grounds of facts or interpretation of the law. By the conclusion of Module 9, you will have learned about how this important outcome area offers taxpayers assurance that disputes with tax authorities will be resolved fairly and in an unbiased manner. After our time together, you'll be able to evaluate to what extent the dispute resolution mechanism in a tax administration system is independent and effective in resolving tax disputes. This knowledge will help you to perform your task as a TADAT assessor for POS 7 in an objective and standardized manner. You will learn about international good practice in resolving tax disputes. You will also find out what indicators and dimensions are used to measure the performance of tax administration with respect to resolving tax disputes. You will learn about the scoring criteria that will help you to score the indicators and dimensions for POS 7. Finally, you will learn what evidence you should gather and what questions you should ask to be able to conduct an objective assessment of this performance area. Let's first look at the desired outcome for POS 7 and then take a glimpse at the background on which dispute resolution is based. The desired outcome of POS 7 is that the process for tax dispute resolution is fair and independent, easily accessible to taxpayers, and effective in resolving disputes in a timely manner. In terms of background, the dispute resolution process should have a legal basis, for example, embedded in the Tax Procedure Code, and should be known and understood by taxpayers. The dispute process must safeguard taxpayers' rights to challenge an assessment and to get a fair hearing. Taxpayers can dispute the accuracy of the facts relied on by the auditor in the assessment, the correctness of interpretation of law, the amount of penalties imposed, and the failure of the tax administration to follow statutory procedures. So, what are the international good practices that guarantee the desired outcome we just discussed will be achieved? Let's discuss the practices shown in the following slide. You will see that the international good practices in tax dispute resolution include the following. The dispute resolution process should be codified in the tax administration law that's applicable to all the core taxes. Taxpayers' rights to challenge the decisions of the tax administration must be published, and auditors must be required to explain the right to appeal and the reasons for adjustment of penalties. The causes of unnecessary disputes must be minimized. The administrative review of objections must be separate from the audit process. Taxpayers should have access to an independent external tribunal or court to review cases of departmental review. Taxpayers should have access to a higher appellate court that can resolve any remaining disputes about legal interpretations and facts. The tax administration should promptly refund any overpaid tax when the dispute is resolved. Conditions for out-of-court settlement must be publicized. Tax administrations should have an automated case management system because it improves the efficiency of the tax administration in resolving disputes. Dispute outcomes should be regularly monitored and analyzed. Now that we know what the good practices are, let's look at the indicators to measure a tax administration system's performance in this outcome area. In the following slides, we will see there are 3 high-level indicators and 5 dimensions for POS 7 about tax dispute resolution. Let's discuss these. The first high-level indicator, P723, addresses the existence of an independent, workable, and graduated dispute resolution process. P723 has 3 dimensions. The first criterion is that an appropriately graduated mechanism for administrative and judicial review must be available and it must be used. The second criterion is that the administrative reviewing process must be independent of the audit process. And the third criterion is that the information within the dispute resolution process must be published and taxpayers must be made aware that it is available. The second indicator, P724, addresses the time taken to resolve disputes. The dimension for P724 is straightforward and is simply the time it takes for completion of administrative review. The third indicator, P725, addresses the degree to which dispute outcomes are acted upon. And the dimension for P725 is the extent to which the tax administration responds to dispute outcomes. Now let's look at these indicators one by one to see how to score the dimensions and the indicators for POS 7. We'll start with P723, which is about the existence and availability of a graduated or multi-level dispute resolution process. Remember, indicator P723 has 3 dimensions. P723-1 addresses the extent to which an appropriately graduated mechanism of administrative and judicial review is available and is used. P723-2 addresses whether the mechanism for administrative review within the tax administration, variously referred to as an objection, a complaint, appeal, or administrative review, is independent of the audit process. And P723-3 addresses whether information about the dispute resolution process is published and whether taxpayers are explicitly made aware of it. In the case of P723, the overall score of the indicator is based on M2, that is, the average of the scores of the 3 dimensions. Let's start with the scoring criteria for dimension P723-1, which is about whether the overall appeal system is appropriately graduated and accessible to taxpayers. Remember, an A-level score represents good practice. A tax administration can get an A-level score if it accomplishes all of the following good practices. The administration has in place a single administrative review process within the tax administration. It is not multi-layered. There is an independent external tribunal or a review board or a court that examines decisions about administrative review if a taxpayer appeals, or there is an alternative fast-track arbitration system. A higher court exists that can resolve any remaining matters of legal interpretation and facts. And the 3-tier appeals mechanism is regularly used. For a B-level score, there isn't a single administrative review process within the tax administration, But there is a multi-layered process. There is an independent external tribunal or review board or a court that examines decisions about administrative review if a taxpayer appeals, or there is an alternative fast-track arbitration system. A higher court exists that can resolve any remaining matters of legal interpretations and facts, and taxpayers use the formal dispute process. Or another scenario for a B-level score is where the administration has in place a single administrative review process within the tax administration. It is not multi-layered. The independent external tribunal, review board, or court that does not exist to hear taxpayers' appeals against decisions of administrative review. However, there is a judicial court process that resolves matters flowing from departmental appeals, and the taxpayers use the formal dispute process. For a C-level score, you do not have a single administrative review process within the tax administration, nor do you have an independent external tribunal or a review board or a court. Both of them are not available. You have only a multi-layered review process within the tax administration, a judicial court process that can resolve matters flowing from departmental appeals, and taxpayers use the formal dispute process. A D score is given when the requirements for a C rating or higher are not met. Now let's look at how we score the second dimension, P723.2, which is about the independence of the administrative review system. A tax administration can get an A-level score if it accomplishes all of the following good practices. 1. The administrative review unit must be physically and organizationally independent of the audit department. 2. Objective review procedures must be documented and applied. To get a B-level score, you do not have an independent separate administrative unit, but you must have designated review officers who are located in the audit department. Also, objective review procedures must be documented and applied. To get a C-level score, the administrative reviews are conducted by auditors separate from those who are involved in auditing the taxpayer. However, you do not have any designated officers for review, but objective review procedures are documented and applied. And a D score is given when the requirements for a C rating or higher are not met. For example, the same auditors who are involved in auditing the taxpayers also conduct the review. Finally, let's look at how we score the third dimension, P723.3, which is about whether information within the dispute process is published and taxpayers are explicitly made aware of it. A tax administration can get an A score if all of the following are present. General information about the taxpayer's rights to appeal, and the process must be publicly available. Auditors and administrative review staff must be required by written instructions to explicitly inform taxpayers of their dispute rights and associated dispute procedures to follow. Audit finalization letters, notices of assessment, and notifications of administrative outcomes must specifically include information about the taxpayer's right to appeal and the procedure to be followed. For a B-level score, general information about the taxpayer's right to appeal and the process must be publicly available. Audit finalization letters, notices of assessment, and notifications of administrative outcomes must specifically include information about the taxpayer's right to appeal and the procedure to be followed. However, tax auditors may not be required to inform taxpayers of their right of objection and the appeal process to follow. For a C-level score, the minimum requirement is that general information about the taxpayer's rights to appeal and the process must be publicly available. However, tax auditors may not be required to inform taxpayers of their rights and the procedures. And assessment or audit letters also may not inform taxpayers of their right to appeal, the procedures to be followed. A D score is given when the requirements for a C rating or higher are not met. Now that we know how to score the 3 dimensions and the indicator for P723, let's look at P724, which is an indicator for the time taken to resolve tax disputes. This indicator has only one dimension, the time taken to complete administrative reviews. Because this indicator has only one dimension, the score of the dimension becomes the score for the indicator. Let's see how this dimension is scored. For evaluating the time taken by the tax administration to complete administrative reviews, the tax administration can get an A-level score if 90% of administrative reviews are completed within the lower of 30 days or the statutory deadline, whichever is lower. To get a B-level score, 90% of administrative reviews must be completed within 60 days or by the statutory deadline, whichever is lower. To get a C-level score, 90% of administrative reviews must be completed within 90 days or by the statutory deadline, whichever is lower. And if the requirements of a C-level rating are not met or information is insufficient, the tax administration will get a D score on this indicator dimension. Finally, we come to the last indicator, P725, which is about the degree to which dispute outcomes or decisions are acted upon. This indicator too has only one dimension, and hence the score of the dimension becomes the score of the indicator. Let's see how this dimension is scored. To get an A-level score on the action taken on dispute outcomes, administrations should regularly monitor and analyze dispute outcomes. And this analysis must be taken into account in the formulation of policy, legislation, and procedures. For a B-level score, monitoring and analysis of dispute outcomes of a material nature, for example, where there is a significant revenue implication or which affects a large number of taxpayers, must be done on a regular basis. Dispute outcomes are taken into account in the formulation of policy, legislation, and procedures. For a C-level score, administrations must do at least some ad hoc monitoring and analysis of dispute outcomes. And dispute outcomes are taken into account, even if in an ad hoc manner, in the last 3 years, in the formulation of policy, legislation, and procedures. Now that we know how to score the indicators, let's look at what information we need to gather for this POA. I would urge you to review Table 23 of the Field Guide for a detailed checklist of questions to ask the tax authorities and to examine the documents that can guide you in the information gathering process and field interviews. Some of the information can be requested from the tax authority in advance, in the pre-assessment phase, in questionnaires and letters, or even when researched from the web. Other evidence and information will need to be observed during the in-country assessment or discussed during interviews with the tax officials during the assessment. As I mentioned, Table 23 contains a complete list of questions. Here, I'll just point out some key questions to ask. What are the legal provisions in tax procedure laws regarding dispute resolution? How many tiers does the system have? Is the Administrative Review Unit organizationally separate from the Audit Department? Is there an independent external tribunal to which taxpayers can appeal if not satisfied by the decision of the Administrative Review Department? Are the administrative and judicial processes independent? Is the dispute resolution system rarely or frequently used? Are taxpayers aware of it? At the time of assessment, are taxpayers told about the right to appeal? Is this information about the appeal process made public? What are the data available for determining the stock and flow of dispute cases? Are they regularly monitored? Does the tax administration routinely monitor the time taken to resolve disputes and the amount in dispute? Are results of appeals made public? At what level? Administrative, tribunal, or judicial stage, or all of them? Are the outcomes of appeals used to determine changes in policy, legislation, and administrative procedures where needed? A complete list of documents and evidence that you should look at is in Table 23, which I mentioned earlier. Now that you've studied the detailed methodology for POS 7, you should be able to conduct an assessment for this outcome area. You've learned about the good practices used in tax dispute resolution systems. You've learned what the indicators and the dimensions are for judging the quality and fairness of dispute resolution. You've also learned how the indicators and dimensions are scored. Finally, you've learned what to look for when gathering evidence for scoring, whom to ask, and where to find useful information. Now you're all set to move to the next POA, which is about efficient revenue management. Thank you very much.